All right, chapter 11 is disclosing and suppressing evidence. So in this chapter, we will learn about the process of discovery in both civil and criminal cases, the difference between formal and informal discoveries, types of evidence that are subjected to mandatory criminal discoveries, exclusionary rules, which is the fruit of a poisonous tree doctrine, and the Miranda versus Arizona, which regulates the process of how the police interrogate their suspects. We'll talk about search warrants, the issue of search warrants, execution of search warrants, major exceptions to the Fourth Amendment, the exclusionary rule of how courtrooms in a work group, and whether exclusionary rule should be abolished or not. The exclusionary rule prohibits the prosecutor from illegally obtaining evidence at trial. So there are 3 grounds that should be justified. The court should not participate in illegal conduct. That's 1. 2 is it deters law enforcement misconduct. And 3 is other remedies civil are unworkable. Fruit of the poisonous tree is excluded from the admission at trial. So the poison, which results directly obtain results of the constitutional violation, then the fruit is the derived evidence that is gained from the knowledge of the first illegal search. For Miranda versus Arizona, Miranda had extensive criminal history, was interrogated by officers until that he failed, signed a written confession admitting guilt. He was found guilty by the jury and was not advised of his constitutional rights during his interrogation. So the Warren court stated his rights were violated and changed the way police handle interrogation ever since. So since that case is how police interrogation has been changed significantly. So some of the thinking points for this was that he admitted to the crimes without being read Miranda, which is admissible in court. Should he be read his rights from Miranda? So should he be read his rights? Like, would that change the way he answers, I guess, the question? Is he less likely to admit to the guilt, or is he more likely to admit something he hasn't done? So I think it's important that people get read their rights, because if they don't get read their rights, then they might admit to something they've never done. They might admit something because they just want to leave, and they feel trapped, and they're just scared. So it's like when you're interrogated, you're put under a lot of pressure. So it could have good causes, but I think it's more negatively. Like, you deserve to know your rights, and deserve a fair trial. So the Fourth Amendment, reasonable clause, search, seizure, warrants, closure, freedom from unreasonable search and seizures, which basically means that I can't just go somewhere just because I want to search. If I'm a police officer, I'm like, I just want to search your house just because. You have to have, maybe if you saw something like a gun, or just have reasonable cause, or you think this person's linked to a crime or linked to a case that you're investigating in, then you can search you can search with cause. You can't just search someone's house because you just want to search. It's not right. Which is also stop and frisk, which is Terry versus the Ohio. So the more thinking points is what should allow officers to approach a person in the street and conduct a Terry pat. Is this justified? Like, can I just walk up to somebody and pat them down? Just because. A lot of people say that could be racist if it's towards a black person, like with a white cop. But I mean, I don't know. I mean, it could be sometimes, but I think overall it does have a good purpose. And I think for the most part, I think it is for the good reason. I mean, it could be used unjustifiably, but I think for the most part it is good, just to be safe. They might make them feel uncomfortable, but you rather make them feel uncomfortable and at least know that they don't have a gun or a weapon on them to harm other people. There's also affidavits, probable cause, probable search, and searching because of a probable reason. So warrantless searches are Case versus Katz versus the U.S. Consent, plain view, innocent to a lawful arrest. So also, like the trial and the decision of the decision makers, defense posture and the prosecutor, and a police officer's testimony. And there is research compared to lack of evidence in witness problems. MAP and Miranda are minor sources of case attrition. Motions to suppress are rarely filed. So when things happen, that's how we learn. Like, when things happen, we put laws and rules in place so it won't happen again in the future. And that's why some of these cases are important, because they're the ones that marked up these new rules and new laws. So pretty interesting chapter. So yeah, and that's about it.